The other big story is the sentencing of Mike Davis. Moments ago, the former 10TV meteorologist walked into the Franklin County Courthouse. The longtime Central Ohio television personality pleaded guilty to child pornography charges. This is a live look inside of the courtroom as we wait for sentencing to get underway. As soon as that starts, we will bring it to you live in its entirety. Now, Davis has admitted to uploading thousands of images of sexually explicit photos involving children. In fact, he faces 29 years in prison and would have to register as a sex offender. While we're waiting for the sentencing hearing to get underway, we'll take a look back at how we got to this point. Davis was first booked into the Franklin County Jail on September 5th of last year after he was arrested on second-degree felony pornography charges. 10TV fired Davis the day after he was arrested on February 6th, and we will now listen in to his sentencing hearing.
Filling out the registration form.
We are here.
Yeah, let me know. You have time now. We're waiting. We have to do one more thing. So you're good.
You're reading my mind.
I know. I can read your mind without seeing your face. Are you media? Yes, you may go into the jury box. Just make sure you're seated 6 feet from someone else. So take the back row and...
I have a seat already. I'm late getting there, sorry.
That's okay. We haven't started yet.
Thank you.
On the form on number 12, I paid exactly years ago.
Ms. Keating will assist.
The judges.
You can just close out.
50, whatever. Here.
Yeah, I think I'm going ahead. It works. I'm going to do yours while we're done. Yeah, please.
I submitted it.
Just to follow that storyline of how we ended up here, after being formally indicted on 4 counts, Davis initially entered a not guilty plea to all charges. That was on October 21st of last year. Then in December, court records revealed that an email account associated with Davis had uploaded nearly 16,000 images of child pornography. Investigators also said that David had been regularly sending child pornography images to himself at other email addresses, and that had been happening since December of 2012. On January 30th of this year, Davis changed his plea to guilty. Here's the moment that the judge asked Davis if he was sure that he wanted to change his plea in court. Looks like we don't have that, but in March, the original sentencing for Davis was rescheduled and then rescheduled once again because of the COVID-19 pandemic. As we've mentioned, Davis is facing up to 29.5 years in prison. Upon his release, he would have to register as a Tier 2 sex offender. His attorney argues that Davis used pornography in an attempt to self-medicate after suffering for years with mental health issues, including severe depression and anxiety. And Mike Davis, again, is in court this morning. We are waiting for the judge to give him his sentence. Let's listen in now.
Ms. Kelly, can you approach? All right.
It's just hit the stop button for it, just adds up.
Okay, at this time, we will go on the record in case 19CR4589, State of Ohio versus Michael Davis. Due to the fact that of the pandemic, this case has been rescheduled a number of times, and again, due to the new order, it was scheduled for next week. However, it was going to get bumped until later in the summer because of the on and off week schedule that the court has now adopted. But defense counsel has asked that we come forward rather than move it later. So we're here today to proceed with sentencing in this matter. Will the parties please enter their appearances?
Karen Keating on behalf of the State of Ohio.
Dan Meyer on behalf of the State of Ohio.
Your Honor, good morning. My name is Terry Sherman. I, along with Taylor Mick, are here on behalf of Michael Davis.
Thank you. Sir, please rise. Are you Mr. Davis?
I am.
Please state your full name and spell your last name for the record.
Michael George Davis, D-A-V-I-S.
Thank you.
Thank you, Judge. There is a presumption of prison for 3 of the 4 counts.
Wait,
that
we have a few steps. Everyone have an opportunity to review the PSI?
Yes, Judge.
Have you reviewed the PSI?
I have, Your Honor.
Any, does the state have any amendments or corrections to the PSI?
No, Your Honor.
Does the defense?
Your Honor, I spoke to that in the last memorandum I submitted to you a couple days ago.
Okay, you 3 may be seated. In regard to sentencing.
Your Honor, there's a presumption of prison for 3 of the 4 counts that the defendant has pled guilty to. The state is asking for an appropriate prison term. I know the court has had the opportunity to review the pre-sentence investigation, as well as sentencing memorandums submitted on behalf of both parties, as well as a number of letters submitted by Mr. Davis's friends and family. The state, in reviewing all of those letters, has a couple things to point out to the court, mainly the harm that was caused to these victims. Understandably, Mr. Davis himself did not cause any of that harm directly. However, his actions create a demand for those images, which results in those children being harmed. Additionally, in viewing the images, some of the images are a bit extreme, more extreme than traditional child pornography, given that it was a particular brand of fetish pornography. There is also no genuine remorse. I understand Mr. Davis has endured a level of embarrassment. However, he has not displayed empathy for those victims, has not admitted that these were for the purpose of sexual gratification. In the reports submitted, in the PSI, he claims that it's hoarding and that he was collecting images that depict children who he refers to as things and it. That is not having empathy for the victims of these offenses, nor is the facts of the case consistent with a hoarding or collecting manner of child pornography. A hoarder or collector of child pornography doesn't delete some of the images. A hoarder doesn't sexually gratify himself to the things that he is collecting. And a hoarder doesn't deny being interested in a particular fetish, yet have both the adult and child pornography images of that fetish on his devices. So for all of those reasons, the state is asking for a period of incarceration due to that and the significant number of images that he had, almost 16,000, which is the largest number that Franklin County Internet Crimes Against Child Task Force detectives can even remember happening in the recent past. Thank you.
Thank you. On behalf of your client, if you would all rise.
Your Honor, I would, if it would be all right with you, I'd rather Michael speak first and allow me to supplement what he says, if that would be okay.
I would prefer that we follow proper procedure.
Very good. I provided, on behalf of Michael, many documents to you. We've submitted at least 3 different memorandums outlining exactly what Michael did do and what he didn't do. We provided information regarding what other courts have done. We provided information as to his therapy and what he's been doing. Additionally, we submitted letters from his friends and people who knew him. We've submitted a medical report. We've submitted several experts' reports. This case has been ongoing since September of 2019. Michael's been out the whole time. He's been under court supervision. He hasn't, he's followed all the rules. He hasn't done anything improper. He hasn't done anything other than attend therapy sessions and try to right some of the wrong. His conduct since September has been non-controversial. The behavior itself that we submit is, and I'm not trying to undermine it, but I think there's a difference in behavior between viewing and other things, and we've tried to point that out. He never sold it, he never distributed it, he never made it, he never did anything but look at it. And I think there's there's some medical and psychological issues, and we try to illuminate that in our memorandum, that I think it's not an excuse or justification, but as to what drove Mike to get involved in this stuff. And we try to point that out to you, and that this really, his behavior is somewhat psychological and psychiatrically bound. He's been getting help. His therapy has been doing well. Even during the pandemic, he's been attending therapy sessions. He's on medication. As far as the number of pictures goes, I don't think, and I try to point that out to you, one of the cases, there was 125 videos of sexual abuse of children that got probation, and there's 30 images per minute, and so there's at least 100,000 pictures. So this isn't the most number, and this case shouldn't be decided by number of pictures, but I don't think number of pictures really means anything. When I got this case, I was shown 4 pictures, and those were what we pled to. I think that if he's not a danger to the community, and he's on the road to rehabilitation, and the only thing left is should we be punitive? Should we send him to prison to show the world that we're punitive? I think a couple of things. Number one, he's 60 years old. He's got some health issues. The dispatch just pointed out that 1 in 10 Ohio inmates have the virus. We have the spread of virus in many Ohio prisons, so if you send him to prison, not to be punitive, you're also not you, but the system is endangering his health. And I don't think that would serve any real purpose here, especially when you've got somebody that's nonviolent, that's doing all the things he should be doing, is on the road to rehabilitation. I'd ask you to give Michael a chance to explain himself, tell you how he feels, to tell you what he's been doing. And I think that we as a community should consider health versus being punitive. We should consider rehabilitation as opposed to punishment, especially in this kind of case. And I think Mike, is given a chance, to do everything he can to right the wrong.
Thank you. Mr. Davis, you do have an opportunity to address the court. If you could wait one moment. Ms. Kelly, can you approach? You may. Thank you. Mr. Davis, you do have an opportunity to speak at this hearing, so you may proceed.
Thank you, Your Honor. First and foremost, I want to say that I have hurt and disappointed and caused pain for all the people I care for most in the world. Since I began series therapy about 9 months ago, I've learned that I've done something that I had no intention of ever doing, something terrible. I've actually victimized children by looking at these images. I didn't realize it at the time, but I definitely realize it now. I've also victimized my wife, my kids, my family, my friends, and all the good people of Central Ohio who've trusted me for over 30 years on television, so I'm very sorry for all that. I have been in intense therapy for almost 9 months, going at least twice a week, sometimes more than that. I have a psychiatrist as well, and I have a new line of therapy that I've just discovered as well that works on making sure that your recovery is solid, so I'm working on that as well. I would like to say that internet pornography is a very dangerous gateway. In fact, it's also a seriously undertreated addiction. Child pornography, though, of course, is far worse. What it really is, I have learned, is child sexual abuse images. And that's something that you can find them anywhere. There are countless victims. And now, understanding the gravity of what I've done, I feel terrible about that. I have no excuse for compulsively collecting the images. It was just something I did, and I'm ashamed of having done it. I have been in therapy to try to deal with that and have come a long way, I think. For the record, I want to state that I have never had interaction with, nor would I ever solicit a child. I am very protective of children, and I am horrified that I have done something that, at least at the time, inadvertently victimized these children, so I feel terrible about that. I want to thank all the people who supported me. I've had a great support group. I want to apologize to my wife and my kids for the terrible ordeal I've put them through. I promise you, Judge Phipps, I will never look at these things again, and I also will continue. I'm very committed to getting healthy and staying that way. I do not believe I am any threat to the community, nor have I ever been, and I couldn't be, despite what I've heard people say, and it kills me to hear them say it, I've been terribly filled with remorse once I realized what I did. Thank you, Your Honor.
Thank you. Do the parties stipulate to 2 days of jail time credit?
Yes, Judge.
Yes.
Thank you. All right. Just so we are clear, I've reviewed a number of things in regarding to consideration of the proper sentence in this matter. Not only have I reviewed the purposes and principles of sentencing that is provided in Revised Code 2929.11, I have also reviewed defense's motion to screen the defendant for admission to CDCF River City that was filed on January 23rd of 2020. I have reviewed the sentencing memorandum of defense with its attachments that was filed on March 13th of 2020. I have reviewed the sentencing memorandum of the state that was filed on March 18th of 2020. I have also reviewed the updated and amended addendum, to the sentencing memorandum by defense with supplemental records that was filed on May 20th of 2020. I've reviewed the PSI. I have reviewed the stop assessment. I have reviewed the mental health and the medical records that were supplied. I have also reviewed all the letters from friends and family. And considering I did order, at the request of defense, a screen for River City CDCF, and the defendant was found acceptable to that program. There are numerous things that I find gravely concerning in this case. To start with, Mr. Davis, you groomed your family and your coworkers to allow you to engage in a sex offense for 7 years and go undetected. You groomed them and you constructed an environment that allowed you to sexually offend at work and at home for a period of 7 years. Somehow you arranged for the time to engage in the behavior, but also you somehow groomed your family and your coworkers to not look at any of the devices you were using to view the pornography, the child pornography and the abuse of children. The facts of the case are horrendous. The number of the images is less concerning than the amount of time that you engaged in the behavior. The fact that the children were as young as 4 to up to the age of teenagers, that the images displayed children in sexual positions, pornography, and the female children were engaging in extremely graphic sexual activity to include child bondage. I will refrain from providing any additional information about the nature of the images. These are victims who were groomed and abused for years to get them to participate in these acts. You chose to support an industry that re-victimized these children over and over for years. I have some concerns about, even though your counsel just said you followed all the rules of bond, I disagree with that. Your attorney, in his supplemental motion, mentioned that you took place in counseling during the pandemic via telehealth. Please describe to the court exactly how you did that. Not what you talked about, but how did that actually happen?
Twice a week, I had an appointment with my therapist, and she would call at a designated time. We'd make an appointment just like we would have had I gone to her office, and then we would converse for an hour, just like, except the only difference is it wasn't face-to-face. So we would do it. I would generally, because she had trouble hearing me where I was staying, I would get in my car, go to an empty mall parking lot because there was no one around, because the malls were closed, and I would sit there and talk to her for an hour just as if I'd gone to her office.
So via telephone or via
Telephone.
Telelink?
No, it was telephone.
No, I have no ability to telelink. It's just telephone.
Okay. And I had the probation officer check your phone. You do have access to the internet on that phone, and you have been on the internet on that phone.
Not for any inappropriate purpose. I did bump into
Sir?
one time I tried.
Sir.
Oh, sir.
It's
Sorry.
my turn to talk.
I'm sorry.
And you're going to remain silent unless I specifically ask you a question that you need to respond to.
Okay, I'm sorry.
You were on the internet looking at wine. Your bond condition said no internet access, period. Not inappropriate access. It says no internet access, period. Another issue with your bond conditions is this. When you pled, I asked you to state your current residence address. At that time, you gave me your home that you were living in at the time of the arrest. And then when you were interviewed by the PSI writer, you did admit that you weren't staying there, that you had to stay in a hotel. It is your responsibility as a condition of bond for the court to know your physical residing address at all times. So that's 2 conditions of bond that you were ignoring. That doesn't bode well in that if you don't follow the conditions of bond, how do I know whether or not you're going to follow the conditions of probation if you were placed on probation? Now I'm going to move on. I reviewed the PSI. The things that concern me out of the PSI are as follows. You engaged in the illegal behavior for 7 years. You did not attempt to get any help whatsoever until you were arrested. You consistently minimize your actions. You acknowledge that there are a number of images, yet as the state has brought out, and even in your PSI when you're being interviewed, you refer to the children as its, and you compare the collection of offensive, illegal pornography of the abuse and repeated abuse of children to the same as toys, comic books, and wine. It is quite disturbing to me that you would compare the abuse of children to any type of object. And this is the worst type of sexual abuse that's videotaped and recorded and pictures are taken because it's children. Children as young as 4. You engaged in the behavior that supports an industry that repeatedly victimizes children. And through this whole period and everything that was submitted to the court and everything you said to the PSI writer, your concern is for yourself. And until today, when you came in front of me, you never once voiced a concern about the children. You have a series of critical thinking errors and beliefs to include denial, justification, minimization, victim stancing, and lack of victim empathy. You refer to children as its, dehumanizing and objectifying your victim, which only leads to an impulse to re-victimize. Children do not willingly engage in any type of sexual behavior. They have been groomed, and they are abused into performing. Each one of the victims that you spent re-victimizing for a period of 7 years. I do not find the claim that you were unaware of what you were doing was a crime or illegal to be credible whatsoever, because you hid it, you did it in private, or you would have been caught a lot sooner. You are a well-educated man who had a career in the public eye. You cannot claim that with your exposure to television that you were not aware of the human trafficking and the sex abuse problems that plague this society. In regard to defense counsel's motion and memorandum, in your original sentencing memorandum, you make arguments as to your opinion that the defendant changed, and I quote, changed his plea to guilty to charges that weren't actually meant what the law was trying to stop. It is wrong to change your plea to guilty and then argue in defense of pleading guilty and in mitigation that you didn't really do what the law said you did. If you didn't do it, then you have a trial and you let a jury or a judge determine whether the state has managed to achieve beyond a reasonable doubt that you are guilty of something. There is repeated reference to Mr. Davis having suffered from numerous mental health issues for years. However, most of what is reported has been self-reporting and nothing has been substantiated by mental health records. The only records, mental health records that the court has to review are the ones that, for the treatment that was received after the defendant was arrested and indicted. Nothing substantiates the claim that you were ever treated for mental health prior to this arrest. It is not surprising that once you are arrested on a felony sentence in which prison is presumed, that you develop anxiety and depression. Anyone sitting in jail thinking about going to prison is going to have anxiety and depression. Counsel has submitted to the court statements like, since his arrest, Mr. Davis has engaged fully and genuinely in intensive behavioral therapy. The court finds that statement to be misleading. I don't doubt that Mr. Davis has engaged in therapy to deal with his depression and anxiety, but nothing in the records I was provided shows that Mr. Davis engaged in any type of sex offender treatment, that there was any work done to control impulse issues. There is nothing in the records that demonstrate that you have been working on your pedophile tendencies and behaviors. The fact that in your most recent records it indicates that you were indulging in alcohol and indulging in overeating shows that nothing's been done for impulse control. And without impulse control, there's no way this court can feel comfortable that someone will not reoffend. There is discussion in the records as to Mr. Davis being a sex addict. However, there is a distinction between being a sex addict and being a pedophile and viewing child pornography. Those do not go together necessarily. There is no research that provides sex addiction is akin to pedophilia. They're two completely different issues. And there's been no therapy regarding either. Nothing in the records indicate that you have been working on either of these issues. Again, everything that I have received indicates that you have been focused on your depression and your anxiety. Now, the defense had submitted a report from Dr. Brahms. Dr. Julie Brahms was retained to conduct a psychological evaluation and to provide a written report to the court. The court has reviewed this report. However, Dr. Brahms was not retained to perform a formal assessment or actuarial risk. Her work must be discounted because of this. Simply, she was not retained to perform a sex offender assessment, meaning that based on what she was asked to do, there were no sex offender test scores or specific measures used in her conclusions. She did not apply any of the standardized tools for evaluation of sex offenders for reoffending or rehabilitation. Without applying any standardized tools while doing an assessment, it's impossible to determine whether someone's amenable to rehabilitation. By comparison, to make it very simple, if I went to the doctor and I told the doctor, I think I have high blood pressure, and the doctor talked to me and looked at me and said, you don't have high blood pressure, without using the standardized tools to check my blood pressure, a diagnosis means nothing. And I want it to be clear, Dr. Abrams did what she was asked to do. I had probation reach out to her, ask additional questions after we received her report, and she did confirm everything I just said. Unfortunately, I can put no value in what she said because she did not assess you in a way that would be helpful to the court. I've reviewed the mental health records, and again, self-reporting of a lifetime of mental health issues doesn't help me and a simple example is, if you were a drug addict and you came before me and you told me, I went to 6 months of inpatient rehab, I've been clean for 12 months, I'm over this problem, yet you provided me no records, I would not be able to consider that in the proper sentencing because I don't have anything to see to show that this has been a lifetime problem. Counsel indicates that you are dedicated to making sure that your counseling will help you with preventing any type of reoffending. However, the records also indicate that you have indulged in alcohol and you have now developed an overeating habit. Each prescription you are on indicates that they have a warning that you should not consume alcohol whatsoever while you are taking the prescribed medication. This also demonstrates to the court that there's been no progress on your impulse control. Nothing this court has reviewed indicates that you have taken one step towards rehabilitation or preventing reoffending. Mr. Sherman, in your motion, you state, actions speak louder than words. You're absolutely right, they do. In mitigation, I have heard since the beginning of this how much you have lost. You lost your job, you lost your position in society, you have lost your home in Arlington, it has ruined your family. I don't doubt that you have suffered embarrassment and humiliation and that you have fallen from this position in society that people rarely have. However, all that rests solely on your shoulders as a result of your own actions that you took part in for 7 years. Any shame, vilification, or any being shunned by your friends and your coworkers, that's all on you, and it's a direct result of what your behavior was for 7 years. The law does not take into consideration your fall from grace when determining the appropriate sentence. And to make it simple, if it did, you deserve a lighter sentence because you had so much to lose, whereas if you were just some poor unemployed guy looking at child porn, he or she should go to prison because she didn't suffer the loss of her job and her life. That's not how sentencing works. Are we holding you up, Mr. Sherman?
No, I'm sorry.
Only viewing the images and not touching a child does not go to mitigation for what you're charged with. You are only charged with viewing images. You're not charged with touching a child. So we're not going to compare what's the appropriate sentences to someone who actually molested a child. And I have reviewed the letters from family and friends, and you are very fortunate to have so many friends and family, and I have taken everything into consideration in regard to that. And just as a reminder, as we discussed, the sentencing is different than usual in this case. If you recall, counts 1, 2, and 4 will have a set sentence, but due to the nature of count 3 and when the date was, it requires an indefinite sentencing range. The following is a sentence that is going to be imposed on the court, by this court. Count 1, the pandering sexually oriented matter involving a minor as a felony of the 2nd degree, receives a sentence of 4 years. Count 2, pandering sexually oriented matter involving a minor as a felony of the 2nd degree, is also a 4-year sentence. Count 3, pandering sexually oriented matters involving a minor as an F2 with an indefinite sentence. So that sentence has a minimum sentence of 4 years and up to 6 years. Count 4, pandering sexually oriented matter involving a minor as a felony of the 4th degree, is a sentence of 12 months. All counts will run concurrent to one another. So the total sentence will be 4 years minimum and up to 6 years for the indefinite portion of that sentence. Costs will be imposed, fines will be waived. At this time, I must remind you of post-release control. As a sex offender, you will be required to serve, after you serve your prison sentence, to be on post-release control for 5 years. That means the adult parole authority has the ability to send you back to prison in increments of 9 months for each violation of your post-release control for up to half of your minimum term of your incarceration. We must also review the registration requirements. My understanding is you've filled out the form already, but let's go over it. So you will be required to report as a Tier 2 offender, which means you will be required to register for 25 years every 180 days. I have the form in front of me. Did you read and review this form with your attorney before you signed it?
Yes.
And is that your signature on line 11?
Yes, Your Honor.
Now, do you understand that you'll be required to register your residence, your place of employment, and any schools that you attend?
Yes, I do.
And do you understand that you will have to report to the sheriff's department in the county that you establish residency?
Yes.
And do you understand that you'll be required to go to the sheriff's department in advance if you intend to move or change either your work or your schooling?
Yes, I do.
And do you understand that if you fail to register as required, that can lead to additional charges?
Yes.
Thank you. We have 2 days of jail time credit. Is there anything else from the state?
No, Judge. Thank you.
Is there anything else from defense?
Would the court consider delaying execution of the sentence until the prison system at least gets control over the COVID-19 virus. The dispatch reported, I think yesterday, that 1 in 10 inmates are been tested positive. Mr. Davis is 60 years of age. He has some health issues, and I presented you statistics that of the COVID deaths, 90% of them are people who are 60 years of age or older. Right now, Ohio prison system is having a huge problem, as you know. It's been all over the papers as to the problems they're having, and I understood the sentence that the court imposed, and I think, though, you're not intending to have him totally destroy his health. I was hoping that you would consider delaying at least at some point until we get the prison system in order. I would like to make a comment about something I said on the memorandum, if you think that's appropriate.
Feel free.
Only point out, Your Honor, I think it's unfair that you would hold Mr. Davis responsible for the argument I made in the initial memorandum. It was on the issue of production. And what I was trying to get across to the court was at the time the statute of production was enacted, that it had a different meaning. It would involve actual production, but because of the advent of the internet and all the things that happened and what production is now was not the intent of the original statute. My argument was that the original statute, Mr. Davis is guilty of viewing, guilty of downloading, but as the original statute was enacted, he wasn't really guilty of the kind of production that caused that statute to distinguish F2s, F4s. That was my argument. I made it because I thought it was a legally sound argument. I don't think that, I'm hoping the court doesn't, and I know you didn't, but that shouldn't be used against Mr. Davis. If you want to use it against me, fine. I thought it was a good argument. I thought it made sense to me. So I apologize.
No, you don't
You
need
misconstrued that, or you took it the wrong way. It's my fault. It's not my fault.
First of all, I didn't take it the wrong way. I took it just like you wrote it. And no, that was nothing that you said was taken into consideration in regard to applying the purposes and principles of 2929-11. In regard to allowing a later report date, does the state have a position?
Judge, I generally do not like report dates. I think that it's best that a defendant go straight from the courtroom to the jail. That way there's no confusion about when and where he has to report. And it also ensures that the court sentence is indeed carried out. We all know the defendants fail to show up for court sometimes, and I would hate for the court's sentence to then not be able to be enforced because Mr. Davis doesn't show up. Additionally, Governor DeWine has issued certain guidance for us in dealing with judicial release hearings, and I think that this would help in this case. The court, or Governor DeWine, has stated that anyone with like a sex offense or violent offenders should remain in jail. This is a sex offense, and so it's the state's position that he should be taken into custody today.
Thank you. At this time, the defendant will be taken into custody and the sentence will be imposed immediately. Thank you. Anything else from the state?
No, Judge.
Anything else from defense?
Mr. Sherman, I have the prison imposed on the, all you have to do is open it and you guys sign it and it's done. I did everything for it. The prison imposed form that has to be filled out. It's right where the sex offender form was. It should say prison imposed. It just has to be opened and signed.
You may be seated to do that.
Yeah.
We're off the record in this matter.